Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, my name is Bulan Ichlasul and I'm here. I will be presenting to you about Brazilian civil law. Introduction. Brazil is a country located on the South American continent, bordered by the Andes Mountain and the Atlantic Ocean. As a former colony of Portugal, the official language used by Brazil is Portuguese. Brazil won its independence on September 7, 1822. Brazil was colonized by Portugal since 1494. Then in 1889, Brazil's government system changed from a monarchy to a republic. Based on the Brazilian constitution, Brazil is a federative republic with a presidential system of government. Thus, the supreme leader is the president. Brazil's current constitution was certified on October 5, 1988. As a democracy, power in Brazil consists of three institutions, namely executive is president, legislative Congress, and the judicial Supreme Court. Brazil Parliament is called Congress and consists of the Senate and the House of Representatives. The Senate consists of 81 members or senators. The term of office for members of the Senate is 8 years. The Brazilian House of Representatives is made up of 513 members, and the term of office for members of the House is 4 years. The President and Vice President, members of the Senate and the House of Representatives, are directly elected by the people through election. The Supreme Court consists of 11 justices. Members of the Supreme Court are appointed by the President, and before being formally appointed as members of the Supreme Court, each must undergo a fit and a proper test in the Senate. Members of the Supreme Court retire when they reach the age of 75. Brazil consists of 26 states and 1 federal district. The capital city of Brasilia DF. Each state and the federal district is led by a governor who is elected through election. Thus, there are 27 governors in Brazil. The term of office of the president, member of the House of Representatives, and governor is 4 years, and it can be re-elected for another 4 years. The president is only eligible to be elected for 2 consecutive terms. The main sources of the rules of evidence that regulate civil proceedings in Brazil are: the first one is the Federal Constitution, which stipulates the general principles related to Brazilian citizens' rights and the constitutional guarantees that Brazilian citizens produce evidence and can access the fullest possible defense, always observing the adversarial principle. The second, the Civil Code, Código Civil, Law number 10406/2002, which stipulates general rules about the interpretation and admissibility of evidence. The third one is the Civil Procedure Code, Código de Processo Civil, Law number 13105/2015, which states the specific on how and when evidence must be produced, and its admissibility and interpretation. The President. The Brazilian Code of Civil Procedure defines specific procedure to create precedents in order to clarify which must be followed by the lower courts. In those procedures, there is a significant openness to the amici curiae participation. The court may also set up a public hearing that is not the hearing for oral arguments to collect relevant information and hear different points of view about the issue that will be decided. The decision in such procedures are binding precedents for the court, internal bodies, and all lower courts for all future disputes regarding the same legal matter, and are rather analogous to precedent in the common law jurisdiction. After such a decision, the Supreme Court shall establish the legal thesis of the President. The legal thesis is a written assertion by the court in which it tries to shape the scope of the President in order to simplify the interpretation and consequently its use in cases where the same matter of law is in dispute, mainly in repetitive cases. Sometimes, the court issue a binding summa for the purpose of simplifying the interpretation of the President. The Brazilian Code of Civil Procedure strengthened the authority of Supreme Court precedent as a source of law, considering that precedent can bind all the lower courts. It also enhanced the authority of other courts' decisions as a precedent in different matters such as civil, criminal, and laboral law when they are made in accordance with certain procedures. According to Article 927 of the Code of Civil Procedure, the Brazilian Supreme Court precedent is binding when they are created. First, number one, in multiple claim appeals. Number two, in a direct constitutional review. Number three, in appeal when the certiorari was granted. Number four, in asuncao de competencia. Or five, by a full court decision. The lower court must follow such Supreme Court precedents. The Brazilian Code of Civil Procedures impose an obligation upon the latter court to explain why a given precedent governs or does not govern the case. If the lower courts fail to observe the Supreme Court precedent, without distinguishing by reason the case at hand or explaining that the given precedent was overruled, the decision may be declared void. On the court, in civil claims, the production of evidence occurs after the statement of claim is filed, although an initial evidence gathering may be undertaken if there is a risk that the evidence will be destroyed. During civil and criminal trials, any party can request the production of evidence. The judge can determine what should be produced. The judge's approval is required before some types of evidence, such as recording of telephone conversation, can be collected. Judges can appoint experts to compile reports and review documents, specify that a parties undergo medical examination, order that documents be archived, and so on. In civil proceedings, the party may appoint their own expert to compile a report in addition to court-appointed expert. This is not possible in criminal proceedings. There are constitutional provisions that allow parties to a case not to produce or submit evidence that negatively affects their case. This also means that in their testimony, parties can omit information that is damaging to their case. This does not apply to witnesses who have been sworn and are obliged to tell the truth under penalty of perjury if caught lying. In civil law, if the documentation submitted is sufficient to allow the judge to review the merits of the case, and therefore the production of oral evidence is not necessary, the judge may opt for an early judgment, where a decision is given without holding a trial. Thank you everyone for watching, and that's all. Wassalamualaikum warahmatullahi wabarakatuh. Thank you.